Court of Appeals of Tennessee is in session.
Thank you, Ms. Dempsey, and on behalf of Judge Bennett and Judge Stafford, we are pleased to welcome counsel to this oral argument, which we are live streaming to fulfill our obligation to maintain open courts. We will conduct the hearing in the same manner as if we were all together in the courtroom, and each side has 15 minutes. The appellant has reserved 2 minutes, I believe, for rebuttal. The appellees, 2 attorneys will argue for the appellees. One of you has been assigned 10 minutes and the other 5 minutes. If I have misstated anything, please speak up, or you may remain silent if you wish, if I got it right. Unless there are any announcements, I'll ask Ms. Dempsey to call the case.
Michael J. Boeh et al. Versus Arthur M. Dial et al.
Your Honor, this is Richard Graves. I'm here on behalf of the plaintiffs and appellants Michael and Anna Boeh. May it please the court. This case arises out of the purchase of a home in Williamson County. And before I get into it, the opposing parties consist of First Energy Land and Infrastructure LLC and their employee Arthur M. Dial. I've collectively referred to those as ELI in the briefing and will do so today. The other defendant is NVR Inc., which also does business as Ryan Homes. I refer to them as NVR. I believe Mr. Fowler may call them Ryan Homes, but those are the same parties. In October of 2016, the plaintiffs Michael and Anna Boeh entered into a contract with defendant NVR. This contract required NVR to construct a new house on a recently platted lot in Williamson County, Tennessee. I believe it was in the city limits of Franklin. The plaintiffs eventually closed on the newly constructed house in April of 2017. After that time, it came to the attention of the parties that the lot upon which the house was constructed was partially located within a FEMA 100-year floodplain. When the subdivision was platted some months prior to that, the subdivision plat did not depict any floodplain encroaching on plaintiff's property. And on the contrary, it depicted the floodplain being separated by some number of yards and not otherwise adjoining plaintiff's property. The subdivision plat was prepared by defendant ELI, and this is what we have been referring to as the original plat in the briefing materials. Eventually, plaintiffs initiated this action based on the failure of them to receive the property as it was depicted on the original plat. And for our purposes here today, the trial court granted summary judgment to defendants ELI and NVR on the 3 following claims. First, the trial court granted summary judgment and dismissed plaintiff's claim for negligent misrepresentation against ELI. I'll discuss that one first. The trial court also dismissed plaintiff's claims for breach of contract and violations of the Tennessee Consumer Protection Act against NVR. First, with respect to negligent misrepresentation. From the nuts and bolts perspective, this appeal concerns whether there's material evidence in the record that the plaintiffs justifiably relied on the representations contained on the original plat, even though the plaintiffs, and it's undisputed, they never personally viewed the original plat prior to closing on their property.
So how can you rely upon something that you never saw or considered?
Well, in this case, Your Honor, the unique facts of this case involve both the local development laws governing the construction of new houses and the obligations of NVR and the contract plaintiffs signed. So here, the plaintiffs entered into a contract for NVR to construct a new house on the property. The local zoning ordinance requires any buildable lot to not contain any portion of the 100-year floodplain. If a subdivided lot contains any portion of the 100-year floodplain, it is a non-buildable lot. Following that, the zoning ordinance requires before any construction can commence that a contractor secure a building permit. Well, a building permit cannot be granted if a proposed construction violates the zoning ordinance. So here, even though plaintiffs never personally viewed the original plat, they contracted for NVR to construct a new house on the property, which NVR did. Plaintiffs would not have closed on the property at closing if there was no house on the lot. The house was only able to have been legally built because the original plat failed to show the true existence of the flood line at that location. So, in essence, I mean, the crux of this claim comes down to plaintiffs are entitled as the non-moving parties to the strongest view of the evidence and all reasonable inferences flowing therefrom. And so it is reasonable to infer that had the original plat correctly shown that plaintiff's lot contained a floodplain, that neither the city of Franklin would have issued a building permit if it knew all the facts before it, because such permit would have been unlawful. And it's also reasonable to infer NVR would not have obtained a building permit that would have been illegal. And at the end of the day, I think that's absolutely a fair inference that the government and the local development board who issues the permits would act lawfully based on the information before it. And really, this is hardly much different than the court's traditional presumption that government action is valid. So that inference, together with the facts concerning the local development requirements and the contractual obligations of NVR to construct a house, show that plaintiffs only closed on the property because of the representations on the original plat.
But when the house was built and when the parties closed, hasn't there been, before the construction, a substantial fill of land to raise the elevation of this lot to be above the floodplain? Didn't that occur?
There was additional fill added to their lot. Now, that occurred after closing. So that occurred after it became apparent that a portion of the flood lot was on plaintiff's property.
Okay.
And so NVR came out, they added fill dirt with the consent of Mr. and Mrs. Boeh. And so eventually the floodplain was removed from the property. However, the flood line on the corrected plat, what we've called the revised plat, was not the same as it was shown on the original plat.
Right.
But even if it was corrected after the corrected, even if the flood line was removed from the property after the fact, that still doesn't change that at the time of closing and prior to that time, NVR could not have obtained a legal building permit. If they hadn't obtained a building permit, they wouldn't have built the house. If they hadn't built the house, plaintiffs would not have closed on the property. So the causal connection is there. And I mentioned,
doesn't fixing it matter?
That only fixing it is a characterization of what occurred. Now, NVR is going to argue we mitigated all of plaintiff's damages. And as for ELI, they did not move for summary judgment on negligent misrepresentation on the issue on the element of damages. They only moved on it with justifiable reliance, but even moving towards the issue of damages. Whatever was done after the property to remove the flood line from the property, that only goes to mitigation of damages. That goes to a measure of damages, and there's still evidence in the record based on plaintiff's testimony that even if the flood line was removed from their property, because the flood line nevertheless directly abuts their property as opposed to being separated by some amount of space, their property is nevertheless less valuable today than it would have been if the flood line was as it was depicted on the original plat.
Haven't they sold the property?
They have sold the property, and however, there is evidence that they would have that the damage. There's still evidence of damages because there's evidence that they would have yielded a higher sale price by had the flood line been separated from the property as shown in the original plat. But even aside from the diminution in value that there's evidence of, there's still their costs of acquiring the property, and this is still.
Counsel, let me ask you a question. The original plat or what you refer to as the original plat, which apparently was some kind of initial plat. What is the significance of that, and what is the testimony regarding what effect that plat had? in this case? In other words, wasn't there some testimony about some other things that needed to be done before anyone could rely upon that original plat?
If I may, so the effect of the original plat is, well, there's several effects, and so I'll just address it by defendant. As to ENR, or as to ELI, this was a subdivision plat they prepared. It was preparing the subdivision regulations, which explicitly state that the subdivision and platting process is for the benefit of future purchasers of land, just like Michael and Anna Boeh as consumers. So the original plat contains the representation for the negligent misrepresentation claim against ELI. As for NVR, the significance of the original plat is significant both for the breach of contract claim and for the Consumer Protection Act claim. As for the breach of contract claim, the contract that the plaintiffs signed with NVR required NVR to convey to plaintiffs the lot, which was lot number 431. It required NVR to convey lot 431 as it was shown on the original plat. And the original plat was incorporated into the contract out of necessity, because without that there's no description of the property to be conveyed and the statute of frauds is not satisfied. But the plat contains the contractual obligation of NVR to convey the property consistent with the plat.
Well, I understand all that, but I think my question more is, wasn't there some things that needed to be done to the original plat? Wasn't that discussed at trial, that as far as the floodplain, it could be modified? Or am I misremembering that?
Okay. So, excuse me, Your Honor. So this was revolved on summary judgment, and there's evidence in the record. I believe ELI put forth some statements of facts that were supported by an affidavit from their surveyor or one of their surveyors. Mr. Willett can correct me if I'm wrong, but the platting process sometimes, but not always, to my understanding, involves showing the location of the FEMA 100-year floodplain. Now, the exact locations of those floodplains are not necessarily always set in stone. I think they can be changed by grading the property and certain things that the engineering can develop. And in fact, the plat in this case did specifically describe 8 or 10 lots in the subdivision as being within a floodplain. And in fact, the line as to those lots, the flood line was described, I believe, as the estimated location of the floodplain, with a note on the plat that eventually the location would be changed to make those buildable lots. However, as to the floodline location with respect to the plaintiff's lot, there's no indication that that line was only an estimation, and the plat otherwise depicted plaintiff's lot as being fully buildable. So, if I haven't fully answered the question, feel free to jump in.
Go ahead. I don't want to take all your time.
Sure. I'll lastly say, just with the breach of contract claim for NVR, the trial court employed contractual language that the grading could change. The trial court, the term grading is not defined in the contract. The trial court used the meaning of grading set forth in the zoning ordinance. And this is the trial court should have instead looked to the ordinary meaning of grading, which would be contained in authorities such as dictionaries, which is the standard this court has. I see my time is winding up. I'll save the rest for rebuttal.
All right, we'll hear from you on rebuttal. Which of the appellees counsel going first?
Good afternoon, Your Honors. This is John Willett with Evans Petrie for Appellees Energy, Land, and Infrastructure, who I'll also refer to as ELI, and Mr. Arthur M. Dial. May it please the court, just to jump in and answer a question I think that was asked about this process. There was undisputed evidence in the statement of material facts and the properly supported motion for summary judgment filed by Mr. Dial and ELI, and I'll just refer to them as ELI, that the FEMA process is a process whereby FEMA designates the location of the 100-year floodplain line as it exists for bodies of water and streams, et cetera. They maintain those lines. They set those lines. it's pretty common. Our engineers testified in their affidavits in support of the motion for summary judgment. Once you develop a subdivision and you fill areas and you create detention basins and you alter the land, you go to FEMA and ask for what's called a letter of map revision, where FEMA then takes a look at your as developed conditions and moves that line based on the fact that the land has now changed. The undisputed facts were that that's a very common process. It happened in this subdivision. It was always contemplated that it would happen. What the undisputed facts also were is that ELI, who performed those engineering services and who submitted the letter of map revision request to FEMA, actually recorded the original plat in this case, which had the Boeh's lot in it, before that process had been completed. It was merely an oversight. The effect of that was that the 100-year floodplain line, as shown in that original plat, was a little off from where it actually ended up as approved by FEMA when we actually completed that process. And what happened specifically in this case is once we recorded that, the Boehs signed a contract to purchase the lot. Obviously, there was no house there when they signed the contract. They closed on that once the house had been constructed. And a few months thereafter, the undisputed statement of facts established that ELI, along with the subdivision developer NVR, knocked on the door and said, hey, we got a little bit of an issue. Don't worry about it. We'll work it out. We got to complete this FEMA floodplain letter of map revision process. They did that. As part of that, I think they had to add a slight bit of fill to the very back corner of plaintiff's yard. In any event, ELI recorded a revised subdivision plat, which clearly shows, it's undisputed, that no portion of plaintiff's property is encroached upon by the 100-year FEMA floodplain line. Now, admittedly, that line did move a few feet closer to where it was depicted as estimated and to where it actually ended up on the revised plat. The plaintiffs do not argue in this case. I think it's important to note when they filed their complaint in this matter, that correction of that oversight had already occurred. So the plaintiffs do not argue that they somehow had an illegal lot, that by the time they filed their complaint that they couldn't live there, that the house was illegal, anything like that. They merely now contend that because allegedly this 100-year floodplain line is closer than it was depicted in the original lot, they have allegedly suffered a diminution of value and damages. We did not attack that fact at the summary judgment stage. We only attacked the prima facie element of a negligent misrepresentation cause of action, justifiable reliance. We alleged that the plaintiffs could not establish that they justifiably relied on any contents of the original plat because it's undisputed, and the plaintiffs admitted in their deposition that they never saw the original plat. They never were provided with any information contained in the original plat. No one ever told them about the contents of the original plat. And frankly, they never bothered to endeavor to discover where the FEMA 100-year floodplain line was whatsoever depicted in the original plat or not. And so we argued that at the summary judgment stage. Unfortunately, as the plaintiffs argue in their appellate brief, there was a problem with the clerk's service of the notice of the summary judgment hearing, in which 2 of the 3 plaintiffs' email addresses were admittedly incorrect. And that was just something that happened at the clerk's end, and it's unfortunate. But the court found that Mr. Wes Weigel, the third of plaintiff's attorneys' email address was correct. And so after the summary judgment was granted by the court, the plaintiffs immediately and timely filed a motion to alter or amend that summary judgment order, claiming that they had not received proper notice of the hearing date. What the court did was the court eventually set a status conference and heard and said that it was going to set a briefing schedule to allow the plaintiffs to respond to the motion for summary judgment and would reset the motion for summary judgment along with plaintiffs' motion to alter or amend, which the court did. So all those things were set to be reheard, and the court reconsidered the motion for summary judgment along with plaintiffs' motion to alter or amend. The court denied plaintiffs' motion to alter or amend, ultimately finding that the plaintiffs had actual notice of the setting of the motion for summary judgment, finding also another grounds to support that denial of the motion to alter or amend is when the plaintiffs filed their Rule 5904 motion to alter or amend, they did not support that motion with any citation to the record, which would demonstrate any disputed material issues of fact, and they did not file a response to the motion for summary judgment or a statement of undisputed facts in response to our statement. So the plaintiffs failed to file a properly supported and timely supported Rule 5904 motion to alter or amend because they simply didn't show that they had a meritorious defense. And we cite some law in our brief for the proposition that in itself means the motion could be denied. Thirdly, what the court really did, and it's just frankly a matter of semantics, the court actually reheard the motion for summary judgment. It allowed the plaintiffs to brief it. We filed a reply brief to the plaintiff's brief. The plaintiffs filed a statement of undisputed facts in response to our statement. The court heard arguments, and the court, in its order denying the plaintiff's motion to alter or amend, again stated that we nevertheless find that summary judgment is appropriate for ELI because the plaintiffs cannot prove the prima facie element of a negligent, misrepresentation cause of action, and that's the prima facie element of justifiable reliance. Court said, look, it's admitted, it's an undisputed fact here that the plaintiffs never relied on any statements contained in the original plat because they simply didn't know about them, and therefore they could not have changed their position in reliance upon any such statements. And we think the court was proper in that. Specifically, what the plaintiffs try to do here is they did not, in response to our motion, cite to any disputed issues of material fact. What they say is, well, look, they've got some creative arguments here that constructive notice should apply because, number one, the original plat was filed as a matter of record in the registrar's office. Therefore, they contend that's notice to the world. And even though they didn't know about it, somehow constructive notice should satisfy their justifiable reliance of a negligent misrepresentation claim, or this idea that because a house was out there when they closed on the contract, that should somehow satisfy the justifiable reliance element, even though they admit that they never knew of those specific representations. I think the problem with the house theory is it involves metaphysical speculation, which is simply impermissible for a motion for summary judgment, because let's face it, what happened is when everybody realized that this process had not been completed, they completed it, right? They corrected the oversight. If, in fact, the original plat had showed the error in there, the plaintiffs are right. Maybe a building permit wouldn't have been granted, and then the error would have been corrected sooner. So the plaintiffs never even would have known about it. So I'm afraid there's too much speculation there for that to somehow constitute notice of where a 100-year floodplain line is located on original plat. I think it's important to focus on the issue here that the plaintiffs do not contend that because they saw a house being built here when they closed on the contract, they were entitled to rely on the fact that it was a legal lot, because it was a lawful lot. What they now say is, well, look, we just think this line is closer than we thought it was going to be, but they never knew where that line was to begin with. They admit that they never investigated where that line was. It just wasn't something they thought about. They were very honest about that. So I would respect
Mr. Willett, did the property line of the plaintiff's property change at any time? I know it was. Okay. All right.
It did not. And I think what the court's referring to earlier, and I'll let Mr. Fowler address this in terms of what the contract said between NVR and the plaintiffs with respect to alteration of the lot. I think there's some language in that contract that allowed, I mean, of course, there was no house built there when they signed the contract to purchase the home. It allowed that lot to be altered and graded. Of course, it would have to be for a house to be constructed thereon. So I think that's what the court was referring to, and I'll let Mr. Fowler address that. But no, as a result of the correction of this oversight, the plaintiff's lot did not change, it did not diminish, it did not move. The FEMA 100-year floodplain line was simply established based on the as-built conditions approved by FEMA. It is undisputed that it does not encroach whatsoever upon plaintiff's property. The plaintiffs merely contend it's a little bit closer than it was shown in the original plat, but the plaintiffs never knew where that line was. It's just not something that they relied on. They didn't change their position based upon that representation. And I think the court need only ask itself, well, what if the revised plat would have been recorded first without the oversight? The plaintiffs would be in the same position. They would still have purchased a house that is lawfully built, and they would now have the floodplain line exactly where it is because they never endeavored to determine where that floodplain line is. So respectfully, we think that the court properly denied the motion to alter amend because really it's a matter of semantics. It'd be an exercise in futility to grant the motion and then turn around and grant my motion for summary judgment in one fell swoop. The court essentially reheard the motion for summary judgment, again considered it, and determined that summary judgment was appropriate because the plaintiffs could not prove all prima facie elements of their negligent misrepresentation cause of action.
All right. Thank you, Mr. Willett. Mr. Fowler?
Yes, good afternoon, Your Honors. I'm Chris Fowler, represent Thomas Sidwell, NVR Mortgage Finance Incorporated, and NVR Inc., doing business as Ryan Homes. I'm happy to call them Ryan Homes for uniformity. Mr. Sidwell and NVR Mortgage have both been dismissed, both during the motion for summary judgment hearing. The remaining causes of action against my client, NVR, for 1, breach of contract, and 2, for violation of the Tennessee Consumer Protection Act. Most of the facts in this case that are substantive are undisputed. The few that relate to my client, I'd like to add. Number 1, when the Boehs interacted with my clients to purchase their home, my clients were the realtors involved. Undisputed that none of these parties had any knowledge of the floodplain issues at that time. It's also undisputed that my clients did not deceive the Boehs in any way because they didn't know about this floodplain issue. Undisputed that the Boehs never reviewed this plat prior to the closing. Undisputed that NVR never represented the original plat. Undisputed that all the parties were operating under this same plat that had the same issues prior to the closing. NVR did build the house on the lot. At the time, and they were allowed to do it. They pulled the permit. It was a buildable lot as far as they knew. And as soon as, and another undisputed fact from the Boehs, as soon as NVR discovered that there was an issue with this floodplain, they immediately went to the Boehs and they said, look, there's a problem, but we're going to fix it. We're going to work with the city, we're going to work with FEMA, and we're going to do what we need to do. And they did. And the most notable fact of this case is that this property is not in a floodplain. Sitting here today, it's not in a floodplain. To answer questions raised by Judge Stafford about the testimony, I think what you're referring to is the language in the contract, which states that NVR, quote, we make no representations or warranty about what other improvements may be constructed within the community. The uses of property adjacent to this, any plan or information you may have seen for this community are subject to change. And then later, as far as what we could do to the surrounding properties are, we're allowed to grade and change the draining system, including the removal of plants and trees, which is exactly what we did to rectify this situation. First cause of action for breach of contract, trial court properly dismissed, because once the repairs were made by NVR, if you have a common sense reading of the contract between these parties and forget this whole metaphysical, if all these things lined up in a row, the Boehs got exactly what they want. They got a house on a buildable lot that was not in a floodplain. I talk about the breach of contract as much as you like, but as far as, I think that's the whole point. It's as simple as it gets, is they got what they bargained for and they got it. As far as the Tennessee Consumer Protection Act, there is no deceptive or unfair statement made by my clients. And second, the Tennessee Consumer Protection Act does not allow for strict liability. Plaintiffs argue that we cannot and we have not cited to any cases to stand for this proposition. And they cite to the Supreme Court case, Gadbenzort versus Russell, and they take half of the sentence. They say actionable fault is not a prerequisite to liability. But then they leave out the second half, which says, in others, the prerequisite could be either knowledge or intent to deceive. And Your Honors, in this case, none of those are present. It's undisputed that there is no actionable fault. We had no knowledge of the problems with the floodplain, and there was no intent to deceive. And that's based on the testimony of the Boehs and undisputed record. The other cases we cite too are Court of Appeals cases, but would all stand for the same proposition. So unless you have any questions, that's our argument.
Hearing no questions, we'll hear rebuttal from the appellate. You need to unmute, Mr. Graves.
Thank you, Your Honor.
You're welcome.
I'll address this in reverse chronological order.
Before you get started, Mr. Graves, let me ask you a quick question, because the term undisputed facts have been thrown around here. Did you file anything either with the original motion for summary judgment or after you discovered the hearing on the motion for summary judgment disputing any of the facts that were presented by the defendants?
We didn't file anything disputing the facts with our motion to alter or amend. I will say ELI's counsel, I think, correctly states that the trial court actually reheard the motion. And in its order setting a hearing for all pending summary judgment motions, it said for us to, or told us to file our summary judgment responsive materials by this past late February, which we did. So ELI hasn't appealed the trial court's allowance for us to do that. I think that's moot. And because the trial court reheard it, I think this court can just review the substance without even having to touch the procedural issues.
Let me follow up with Judge Stafford's question. Is it correct that there was no disputed facts asserted in response to the movement's statement of undisputed facts?
We filed our statement. We filed our response disputing many facts.
Did you file, as Rule 56 requires, point by point, citing to affidavits and depositions to dispute the facts asserted by the movement?
Yes, we did that this past February or March. In prior.
So you filed a statement of disputed facts?
Yes.
Okay, thank you.
I believe I'm out of time. I won't try to press anything in these last 8 seconds, but that's
all right. Well, thank you all for your good arguments in an interesting case. We will take this matter under advisement. Ms. Dempsey, you need to unmute as well.
This honorable court is in recess until 2:30 p.m.
Thank you, Ms. Dempsey, and thank you, counsel, and you're free to exit the meeting.
Thank you.